of Appeals is now in session. The Honorable Sean Quinn presiding.
Good morning, everyone. Please be seated. Happy St. Patrick's Day.
Oh, that's right.
Okay.
It starts at noon.
Yeah, I got a green shirt. I'm ready. Anyway, good morning again. I'm Judge Sean Quinn. Today is Monday, March 17, 2025. Today is also the 10-year anniversary of our marshal being a member of our court. So happy anniversary. I did it. Aha. We only have one case scheduled today. Konneh, is that pronouncing that right? Konneh? Konneh v. Sundog Enterprises. It's our file number WC246589. In addition to myself, our panel today is made up of Judge Tom Christensen on my left and Judge Kathy Carlson on my right. Be closer. Today's argument is being live streamed and recorded. The acoustics in this room are not particularly good, and sometimes the mics are not very sensitive. That's why I got to lean forward. We ask when you present your argument to the court, speak loudly, clearly, and into the microphone. As to timing rules, you each have 15 minutes for your respective arguments. We'll give each attorney 3 minutes of uninterrupted time to start. You can use those 3 minutes any way you deem appropriate. Ideally, you would use those to outline your entire argument and let the court know the relief you seek from this court for your client. Once your 3 minutes are up, I'll stop you and ask members of the court if they have questions. As to the 15 total minutes, the burden is on you to keep track with the clock on the dais. The light will turn yellow when you have 2 minutes remaining. When your time expires, we may allow additional time if we have additional questions. If not, however, your time is up. Should the allotted time of one party be extended because of questioning from the court, we will extend the same courtesy to opposing counsel for a similar amount of time. Appellant's counsel may reserve as much or as little of the 15 minutes for rebuttal. You don't have to tell us that you're going to do that or how much you want to use. Just keep track of your time, and when you're back up on rebuttal, the marshal will put the remaining time on your clock. When you step up to the podium, identify yourself and the party you represent. With that, Ms. Borash, you may begin.
Thank you. Good morning. My name is Tracy Borash, and I represent Synergy Enterprises, doing business as Synergy Home and its insurer technology insurance company and AmTrust in this matter. The employer and insurer have appealed the compensation judge's findings in order in this case, as her findings are not supported by substantial evidence in the record. Specifically, the employer and insurer believe that the employee did not sustain a permanent right knee injury as a result of her work injury, that she did not sustain any type of low back injury at the time of the injury, and that she is not entitled to wage loss benefits after she was released without restrictions. I will take each of these items in turn. The first is the right knee injury. The compensation judge erroneously found that the employee sustained a permanent right knee injury due to the incident of April 23, 2021. As indicated in the brief, on that day, Ms. Konneh slipped while descending a staircase. When this happened, her right foot slipped, skipped over 2 steps, and landed very hard on the next one. She did not testify that she twisted her knee in any way. Ms. Konneh underwent a right knee MRI on May 13, 2021. It showed absolutely no evidence of any tearing in her knee whatsoever. It did show advanced arthritis, essentially, of the patella and a small area of cartilage loss, but that was all. There was absolutely no evidence, again, of any tearing of the meniscus. After the MRI, she underwent considerable therapy through July 19, 2022. Even in her findings, the compensation judge mentioned that when she was involved in physical therapy during the summer of 2022, she reported feeling stronger, and she reported being able to walk 35 minutes at a time at a fast pace. The evidence shows that after that date, Ms. Konneh did not seek out any medical treatment for her right knee until November 3, 2022, where she reported a flare-up that started a week ago, meaning in October. The compensation judge never mentioned in her findings and order the cause for her return for treatment in November 2022. When she was seen on November 4, 2022, she complained of 10 out of 10 pain with walking, whereas 6 months before, again, she was able to walk 35 minutes at a fast pace. She continued to treat after November 2022. Her records show that she had to walk with a cane. She was not walking with a cane before then, before October 2022. She eventually underwent another MRI in May 2023, which for the first time showed a tear in the right knee that was later described as a root tear.
All right, Ms. Borish, I'm going to stop you there. Questions? Go ahead.
Okay, thank you. Ms. Borish, first of all, I'm going to just nitpick a little bit on the wording. You indicated here this morning and also in your brief that there was a finding of a permanent injury to a right knee. I didn't find that finding. I read it as the judge saying that the injury still contributes to her need for medical treatment and disability, but not a specific finding of a permanent injury. And like I said, it's a little nitpicky, but I think it's important for our decision. Would you agree with that?
One moment, Your Honor. I think you are correct in that her actual findings, she says that she doesn't mention sustaining a permanent injury, but the fact that she was injured in 2021 and by the hearing in 2024, it was clearly still ongoing, makes it more than a temporary injury, the one that was found by Dr. Wickland.
Okay, so your concern is the kind of ongoing liability for the injury, regardless of the word permanent.
Correct.
Okay.
Correct. So I apologize for that mistake.
Yeah, no, it was just for clarification. It wasn't.
Yeah.
Okay. And my next question, and I'll pass it on after this. Also in your brief, you discussed how the judge did not provide any explanation as to how the work injury caused the root tear.
Correct.
Is there anything in the medical records that describes the cause of the root tear? And again, to be clear, we're talking about the root tear that was discovered 2 years later with a subsequent MRI.
There are actually two opinions in the medical evidence. The first is from the employee's treating doctor who reviewed the MRI and noted that the root tear was quote unquote new. Those were the words that he used in his record. And he attributed it to a catabolic event. But that was all. He didn't say that catabolic event was due to the work injury. He just said the tear was due to that. The second causation opinion comes from Dr. Wickland, who in his third report explained that the catabolic event was due to the just natural progression of her underlying degenerative condition. Because when she was seen for that first MRI in 2021, again, she had some chondral loss in her knee. No one has said that the work injury has caused that, aggravated it, accelerated it. But from that point through the next MRI 2 years later, his opinion was that that underlying degenerative condition, exactly pretty much rubbing of the two areas of her knee where there was the chondral loss, that caused the root tear.
So the treating doctor, and I forget if it was Griffin or Huang, that said that it was caused by a catabolic event. Is that enough for the employee to meet her burden of proof to show that it was caused by the work injury?
I do not think that it is. Obviously, she had underlying degenerative problems before her work injury. The employee did not provide any type of causation or narrative opinion linking the catabolic event to the work injury. So simply stating it's a catabolic event without providing more substance, more opinions tying that to the work injury. I do not think that that's enough.
Thank you.
And then I have a question just following up on that same area. In finding 39, the compensation judge wrote, Dr. Griffith opined the employee's knee was a catabolic environment causing destruction, including the large root tear. And I've looked and I'm not quite sure what catabolic means. So if you can help me with a definition, it would be helpful to me. Thank you.
I think if you look at Dr. Wickland's third report, he discusses what the catabolic event, what his take on that term means. Again, as you said, Dr. Griffith did not describe what he meant by that. Dr. Wickland is the only one who's provided any sort of opinion on that. So a catabolic event, no, that's a good question. I don't even know what that means, other than what Dr. Wickland feels in his report it's attributed to. And I think that's one of the problems in this case is that we don't have an opinion from Dr. Griffith explaining what he meant by that and linking that to the work injury.
And again, I've looked and I don't see anywhere following that entry on or finding on 39, anywhere in the record where Dr. Griffith explains what a catabolic environment is. Are you able to help me find anything else?
No, he mentions it one time, and that's all. So he doesn't go on to give any sort of explanation as to what he meant by using those terms, that terminology, and specifically never mentions how it's linked to the work injury, given the fact that she had an MRI 2 years earlier that showed absolutely no tearing in her right knee. Okay. All right. So again, as we talked about, the root tear is a new finding that wasn't there before. We believe that the compensation judge neglected to address these items when she made her findings in order, that the right knee injury was not necessarily permanent, but ongoing at the time of the hearing.
All right, now the one thing that the compensation judge does do in her, I can't remember, it must be the memorandum, is she says something along the lines of, well, the employee may have had all this pre-existing stuff going on in her knee, but she was, always able to work and never had real restrictions. And then after this work injury, it's just a series of events ultimately leading to, finding of a tear in the meniscus and so forth. Now, I know you put a lot of stock in that gap in time between July and November of 21 or 2. Other than that, I mean, is there something else? And I'm not suggesting that that's not enough, but other than that, is there something else that, is missing, or can we rely upon the compensation judge saying, well, it's still an ongoing thing, so that's why I found it to be an ongoing thing?
I think you're right. There is this gap in treatment. There's a gap in her symptoms. When you look at her symptoms before the gap started, she was by all accounts doing really well. She could walk, like I said, for 35 minutes. She didn't have a cane. She didn't have anything. Then in November of 2022, she goes back to the doctor and reports some event. Well, actually, she didn't say there was an event. Right. She said that she had a flare up a week before in October of 2022. And then after that, you get the MRI that shows the new tear. The compensation judge, in making her decision, relied upon the employee's statements. And she did say that the employee was credible when she talked about her symptoms after the injury. But it's the employer and insurer believe that she was not, she essentially was not credible. When she was asked about her symptoms before the work injury, the judge said that she really wasn't a great historian. But when you look at the actual testimony she gave, she couldn't recall anything about these prior problems. problems where she had 10 out of 10 pain, problems where she couldn't walk, and multiple times where she had 10 out of 10 pain, where she couldn't walk. There were times when she couldn't work, whether it was for her low back or her knee or both. But at her test, at her at the hearing, she couldn't recall any of that. So you have to look at what the judge relied on. She relied upon the employee saying she had continued symptoms. And it's not just, and so we believe that her reliance upon that was misplaced.
And just a bit of a follow-up on that. In the memorandum, so this is not a finding that was specifically appealed, but in the memorandum, under right knee injury, the judge outlines things that she had considered in making her decision. And one of them was the nature of the employee's pre-existing condition was not significant and did not rise to the level of necessitating work restrictions, MR imaging, injection therapy, aspirations, or surgery. Do you agree with that? Are all of those statements true, or is that different than what you just said?
I do not believe that that is necessarily correct. She definitely had more treatment for her low back before the work injury than she did for her right knee. That I will agree with. But she did report problems with her right knee before the work injury. An example, in 2015, she felt her knee would go out of place at times. There's an example. She returned to her doctor in December 2015 for complaints of bilateral chronic knee pain. So I will give the judge, I will agree with her in terms of she did not have a lot of pre-existing problems, but she did have some. And I would like to reserve my last minute.
Okay.
Thank you.
Very good. Thank you. Mr. Reichert.
Good morning, Your Honors. It is incorrect to say that the testimony of the employee did not include her identifying a twisting of her knee. And I direct the court to page 34 of the transcript at line 25, and there she uses the word twisted. So she did twist her knee. Regarding the right knee injury, the independent medical examiner originally found that there was a temporary aggravation of her underlying knee condition. So we first can look at the MRI that was done 3 weeks after the injury, the slip here, on May 13th of 2021. And there, the findings show that there was damage and deterioration to this knee. I'm not going to read that to you, but it is in the record. It's also in my brief at page 3 at the bottom. But that's the condition of her knee immediately after this slip and twist injury. The MRI, the IME that was done about a year later found that she had aggravated that underlying condition because that underlying condition was now symptomatic. That's the change. And the doctor, the independent medical examiner, identified that as the change to the underlying condition. We all acknowledge that she had a poor underlying condition in her knee, but this injury accelerated that. And she testified credibly throughout the trial that she has had swelling on that knee consistently since this injury, to the point where there were several aspirations of the knee to remove fluid buildup on the knee. These are the differences that occurred to her knee following this injury, and these were not things that she had encountered prior to this injury. And the symptoms have not gone away. So the independent medical examiner changed his mind, but he didn't change the underlying condition, which is established by the MRI 3 weeks after her injury. And it didn't change the symptomology. The asymptomatic change to symptomatic has not changed. She remains symptomatic to this day. There have been deterioration and changes to the knee. And there was some discussion here with the court about the meaning of catabolic, and its catabolic environment is the use that Dr. Griffin made of that phrase. So it's catabolic environment. So he's talking about the inside of the knee as depicted in that MRI 3 weeks after the injury. And that injury, the catabolic part of it is the breaking down of the cellular structure by the body. That's what's happening inside of that knee. That's when Dr. Griffith calls it a catabolic environment. He's talking about an environment that is destroying itself for whatever reason, because maybe there's bone on bone, because maybe these tears are small, but they're getting worse. Maybe the knee isn't operating in the fashion that it's supposed to. But this environment that he identifies as catabolic, as destructive, is what is going on. And this environment...
I'm going to interrupt you now, Mr.
Sure.
Reichert. Questions?
I'm happy to go first again.
Go first.
Okay.
Yeah.
Mr. Reichert, it's nice to hear your explanation of catabolic environment. It would have been really nice if Dr. Griffin or some other medical supporting person would have explained that to us. I'm not saying that you're wrong, but I don't see anything in the medical evidence where a doctor explains that or gives a causation opinion. Can you point us to the evidence, not your advocacy, and I do appreciate it, but can you point us to any evidence that supports what you just said?
Only the discussions of Dr. Griffin. Dr. Griffin discusses this. He doesn't define catabolic. I agree, Your Honor. That's sort of a shortcoming here. But it is a medical term of art. It's being used as a medical term of art. And when you look at catabolic as it applies to living things or to a functioning biological entity, that's what it means. It means self-destruction.
Well, let me kind of rephrase the question. Is there any evidence that provides a causation opinion that we can read as saying the work injury caused, accelerated, or aggravated this environment or condition or symptoms?
I don't think so, other than the documentation of the change that the employee reported. That is that the swelling was now present, that there was fluid that was now having to be removed, and that she was had pain from this knee and was limiting herself, both based on the restrictions of her doctor and her own self-limiting. But no, there's not a doctor saying A led to B led to C.
Thank you.
In that regard, and you heard Ms. Borash talk about it today, and she talked about it in her brief too. In July of 2022, the employee reports to her physical therapist, I'm feeling stronger, I'm able to walk more, I'm doing good. She doesn't say I'm 100% better. I agree with that, but that's what she says. I'm stronger. I'm able to walk more. And then she doesn't treat for a long time. Long time is maybe not the right word. She doesn't treat for 3-4 months. And now she goes in and says, I had a flare-up. We don't have anything in the records. I don't recall seeing anything in the testimony that described anything that caused a flare-up, and there doesn't have to be a cause of a flare-up. I get that. Dr. Wicklund says, okay, it was a temporary injury. It resolved in that July time, and then it came back in November for whatever reason, but not the work injury. Do we have anything that says to the contrary?
I'm sorry, Your Honor. Ask the question one more
Okay,
time.
so-
I lost it.
All right, so Dr. Wicklund says it's temporary.
Yes.
And the temporary injury resolved by July of 2022, a little over a year after the work injury. Do we have anything that says, no, there was continued ongoing symptomatology? There certainly was no treatment, but there was ongoing symptomatology after July and before this flare-up in November.
Yeah, yes, I think first off, we have the employee's testimony about this constant pain and swelling in the knee. And that didn't change even if she wasn't doctoring or getting physical therapy. So that she describes her restrictions at various parts of the transcript, but I would first just point the court to pages 52 and 53 of the transcript, where she describes no restrictions and no problems. These are the very things that the court was discussing with counsel here about the change in the findings, that she had no restrictions, no MRIs, no medications prior to this injury. But then at pages 42, 43, 44, and page 90, she talks about the restrictions, and she talks about the problems that she has had that necessitate the restrictions, and that these problems are the problems that arose from the slip on the stairway. So she describes a continuum of these problems without relenting. There isn't a break. She may have had a break in getting care, but the care wasn't changing the underlying condition. It was just giving her some tools to live with it better. And so that's what she did for that period of July through November. But then it just became intolerable again. And that's the nature of her injury here, is that, the nature of her injury is that she can have good days and bad days. There's a part in the testimony in one of those pages, I think it's 42 or 44, where she talks about when she doesn't ice her knee at night and she goes to bed without icing it, and the difficulty she has the next morning. So she knows that if she doesn't do these things to her body, it will not function in a way that will allow her to continue to work. Just briefly addressing the employee's credibility here. The judge, first off, it is the function of the trier of fact to assess the credibility, and I'm not going to bore this court with that. You know this. But here, there is nothing manifestly contrary to the weight of the evidence. The credibility of the employee was assessed by the judge. She determined that the employee was not lying. She was a poor historian, but that doesn't make her a liar. And that's the argument of the insurer and employer, is that, well, if you're a poor historian, you must be lying. No. And she repeatedly, at pages 58 and 59, she agrees that with counsel that she can't recall these things. At pages 74 and 75, she again says,
Mr. Reichert, I'm going to cut you off. I agree with you on credibility assessments, but I am troubled that the judge found her testimony for the condition before the injury to be unreliable, I think is what she said. And when you're looking at medical evidence to support the claim, and there is a poor history, or in this case, even a no history with the doctors that are commenting, other than Dr. Wicklund, on her condition, being an unreliable historian is relevant to what those doctors understood when they are writing their words down. Do you agree with that?
I agree with that to a certain extent, but I think that the MRI done 3 weeks after this injury took place is more telling about her condition than anything she could historically report. And the historical report would be just what the judge said. No MRIs, no physical therapy, no medication. So there's sort of an absence of something there and she didn't remember it. But when she was confronted with it, she didn't deny it. She never denied it once.
So I'm understanding your argument to be, despite no medical causation opinion, the employee's testimony alone is enough to satisfy the burden of proof, and that's what you've done.
It's more than that. It's the employee's testimony alone is substantial enough to move that burden forward. But her treating physicians interviewed her, had a work history from her, understood the nature of her complaints following that history that they took from her, and all of that related back to this slip on the stairway. And they relied on those notes and their own notes, and the fact that she was reporting these things to them consistently from the date of injury. So I think there is doctor causation here. They continued to treat her. They continued to support her. They continued to prescribe things like a knee unloader brace.
But that doesn't create causation. I don't think there's any dispute your client's got a terrible knee. I mean, she needs total knee replacement at a very young age. I understand why she hasn't had it yet for that reason. But just because her knee is a mess doesn't mean that it's from the work injury. I mean, I'm very troubled by the fact that there's an MRI right after the injury. And then about 2 years later, there's another MRI that shows a substantial change in those 2 years. And not a single doctor saying the work injury played a role in that change. That bothers me.
I think Dr. Griffith, when he's talking about that catabolic environment, is referring to that first MRI and the condition that she had after the slip and fall. So when he, in May, I think that's May of 23 is when he uses that phrase.
He says there's a prior MRI with no evidence of the meniscus tear. There's clearly a catabolic environment causing destruction, where now she has a large root tear. Okay, so she didn't have a meniscus tear. Now she's got this catabolic environment causing the tear. That I would like to think that he would say, to help your client at least, your client's claim, and the work injury is part of that catabolic environment. That's one of the substantial factors playing a role here. Something, I mean, I don't expect treating doctors to write, narrative reports in their treatment notes. But I'm struggling connecting that as a causation opinion to the work injury.
Well, and I understand that, and I'm certainly going to fall back on my original opening remarks here regarding the independent medical examiner who did find that there was an injury, did base it on the fact that she was asymptomatic prior to it, just like the judge in her decision wrote, and then became symptomatic after that.
And he still stands by that. His last report, he still says there's a temporary injury. Your client, he admits your client, or opines your client has a temporary injury, but temporary, it ended. That's what he says.
Right, and we disagree with the end date.
Right.
He says it ended, but there is no change in that symptomology. She didn't become asymptomatic again. She's still symptomatic. That's what he said was the manifestation of her injury. And the symptoms have not gone away. I'm out of time here.
Mr. Riker, I just have one question, and we'll make sure that there's even time. I want to talk about the low back just for a second. Was that a specific injury, or was that a consequential injury?
My understanding is that it was probably a consequential injury of this twisting motion. It wasn't discovered right away because of the knee pain. And I think the record is very clear. When she was first seen for the knee, her pain was 9 out of 10. She was there because her condition had worsened. So it was worse on the day she was seen by the doctor than on the day of injury. That's why she went to the doctor.
Well, the physical therapy notes reference that her back was getting worse because of the way she was walking because of her knee. And I didn't see any medical discussion as to exactly what caused her low back pain. Can you point me to something in the evidence that explains how the back pain came about?
I can only point you to the two May 3rd of 2021 Tria report where she's being looked at for right hip pain and knee pain. And then then she's back on the 7th, a couple days later at Tria for hip pain follow-up, but also a worsening of the back pain. But that it's all discussed as part of her slip and fall.
Okay, thank you.
Any additional questions? I'll look myself. Okay, very good.
I'm out of time.
Thank you, Mr. Reichert. Ms. Boresh, we'll give you 2 minutes since we went out extra for Mr. Reichert.
All right, thank you. Just to follow up in some of the arguments that were made, a statement was made that everyone agrees that the injury accelerated her underlying knee condition. That is not the case. Dr. Wickland, granted, in his first report, he said that she had a permanent injury. But when you look at the report and the arguments made in the brief, he did not have her pre-existing records when he made that determination. The second report, that's when he received all of the pre-existing medical records, all the records that had gone on since his first exam, And that is when he said that it was a temporary aggravation. So to say that it was more than a temporary aggravation of her knee condition is not correct. When you're talking about, I just want to pick up on some of the things you just described about the low back. So the low back, in her initial injury report that she filled out, Ms. Konneh did not mention her low back. There was a diagram where she was supposed to circle the body parts. She did not do the low back. Yet when she testified at the hearing, she testified that by the time she got home, she recalled experiencing pain in her back and not really feeling pain in her knee. It wasn't until a few days after the injury she began to notice that her knees were swelling up. So to now claim that the low back is due to consequence of her walking goes contrary to what Judge Marshall found to be credible testimony about the condition of her low back. So the employee testified at the hearing she had low back symptoms essentially since day one. Her medical records do not say that at all. Her medical records say that she only had problems with her right knee. And that is why the employer sure believed that Dr. Wickland's opinion should be adopted, where he says that there was no injury to the low back. And I'm out of time, right on time.
Any other questions?
No.
Anyone? Okay, thank you both.
All right, thank you.
The record is now closed. The court will issue a decision within 90 days of today's date, and we are adjourned.